this morning's docket. That is case number 105698, Duskin Saruda, by and behalf of the heirs of at law of Tate Dillon Saruda, deceased, v. Melissa Saruda.
Your Honor, Tim King appearing for Plaintiff Appellant Duskin Saruda. I request that I be allowed 5 minutes rebuttal time, please.
5 minutes is granted.
Thank you. If it please the court, the trial court in this action erred when it instructed the jury that it must compare the fault of the plaintiff appellant for a single car rollover accident which killed the couple's 7-year-old son, that they must compare his fault even though he was asleep at the time of the accident when his wife wrecked the car. The instruction given by the trial court to the jury was directly contrary to this court's ruling in the Aiken versus Hamblin case that in the absence of a joint venture or a special relationship, a passenger owes no duty to other passengers. So in this case, Duskin Saruda, the passenger in the front seat, owed no duty to Tate Saruda, the passenger, one of the passengers in the back seat, to control the actions of the driver, Mrs. Saruda, to prevent the accident. And that's an important distinction in this case, is did Duskin Saruda have a duty to control the driver, his wife, to prevent injury, not to himself, but to prevent injury to the couple's son in the back seat. After receiving this erroneous instruction, the jury found that the plaintiff, although he was sleeping at the time of the accident, was 50% at fault and barred him from receiving any recovery for the death of his son. Duskin and Melissa Saruda had one child, Tate Saruda, who was 7 years old at the time of his death. This accident occurred on Sunday, March 22nd, 2009. Tate liked to compete in wrestling tournaments, and on Saturday, March 21st, 2009, the day before the accident, Duskin and Melissa Saruda took Tate and a friend to Ottawa, Kansas, so he could compete in a state wrestling tournament. The tournament started about 9 o'clock on Sunday morning and concluded between 5 and 6 p.m. on Sunday night. The Sarudas, their son, and then Connor, a 6 or 7 year old friend of Tate who also competed in the tournament, left Ottawa, drove to Lawrence and ate supper, and then drove from Lawrence to Topeka where they stopped for gasoline. Duskin Saruda, the father, drove from Ottawa to Lawrence and to Topeka. The group then traveled west on I-70 to Salina. They were headed to their home in Colby in Thomas County, way in western Kansas. Mrs. Saruda drove the leg of the trip from Topeka to Salina, 111 miles. In Salina, Duskin Saruda and his wife, Melissa, switched drivers, and Duskin drove from Salina to Waukegan, 128 miles. Melissa and her husband, Duskin, agreed that if she would drive from Waukegan to Oakley, their next usual stop, that he would take over and drive the rest of the way home to Colby. The distance from Waukegan to Oakley is 55 miles. The accident occurred in Gove County just a few minutes before midnight when Melissa was driving and Duskin was asleep. After Melissa started driving at Waukegan, she did not tell Duskin that she was too tired to drive, and her driving did not cause Duskin to think that there was any reason to have concern for anyone's safety. And before going to sleep, Duskin asked Melissa, "Can I take a nap? Are you all right? Are you fine?" To which she said yes.
And given those facts, this kind of jumps ahead to the cross appeal, but I think it's relevant to the issue of reversibility of any claim of instructional error that you're raising. Doesn't that seem to be almost as a matter of law, a joint enterprise?
No, I don't think it does, Your Honor. It does, Your Honor. I think if she were to say to him, yes, I am so tired, I cannot sleep, I have to go to sleep, I'm too tired to drive, then yes, that would be a concern.
Why is that necessary? I mean, you have them sharing the driving duties, it's a joint car, making joint decisions about when and where they're going to stop, the time that they're going to drive, that they're going to drive through. They have a shared responsibility for all of this.
Mm-hmm.
Isn't that a classic joint enterprise situation?
I don't think so, Judge. My argument to the trial court is if you read most of the joint enterprise cases, they're in a commercial context, tag team truck drivers or something like that. If we were to get on joint enterprise, every time a husband and wife got in a car to go run groceries or go out to eat or take the kids to the soccer tournament, then that's a joint enterprise. And I don't think that's what we have in this situation. And the court did not give a joint enterprise instruction. And had they, I think it might have significantly changed the outcome of the case. So the judge ended up giving a hybrid of instructions that was neither fish nor fowl to fit this case.
Either side request a joint enterprise?
Yes,
instruction?
the defense requested a joint enterprise instruction, which was not given.
And so the reason it should not have been given is because you would say that a joint enterprise instruction is never appropriate in a private situation? It has to be a commercial situation?
I would not say never, Your Honor. It's just that it's generally, I was not able to find a joint enterprise instruction outside of a commercial context. I was not able to find a joint enterprise instruction where it's a husband and wife on family business. Again, every time a husband and wife get in a car, that's a joint enterprise.
Is there any element of joint enterprise that you think is not satisfied because of that husband-wife relationship, or? I mean, what part of the joint enterprise elements are not satisfied?
In order for there to be a joint enterprise, there must be a common purpose to occupy the vehicle, and that each party has right to control and manage the operation. Understanding that the passenger has the right and is possessed of equal authority to prescribe the use and conditions of the vehicle. And again, I don't think outside of a commercial context you can have that every time a husband and wife get in a car.
Just as a practical matter, you're saying?
Yes.
I mean, you're just declaring that that should be the law, but you're not telling us that there's some case out there that says commercial's the only setting for a joint enterprise or joint venture.
Correct. And again, if a joint enterprise instruction would have been given, I wouldn't be standing before you today, because the jury would have had a right, I think, arguably, to find that there was a joint enterprise. But a joint enterprise instruction was not given that tells them the negligence of Duskin is the negligence of Melissa, and the negligence of Melissa is the negligence of Duskin. They were told what is her negligence, what is his negligence. The negligence is not imputed to one another. And again, we ended up with this hodgepodge of instructions that didn't fit the situation.
And that's kind of my ultimate question is, if we would decide that that joint enterprise instruction should have been given, then any error that you have alleged would be harmless, basically? Because that would have been imputed to her? Her negligence would have been imputed to him?
Again, I don't know, Judge, because that would have changed the oral argument, that would have changed closing argument, that would have changed the outcome of the trial. I mean, it would have been, if I knew going into the last day of trial that there was going to be a joint enterprise instruction, I probably would have gone about things differently. But again, I don't know. I can't look back and say, well, if then this, because the joint enterprise instruction wasn't given.
So if there's your position is there shouldn't have been a joint enterprise.
Correct.
Which then there shouldn't have been a comparative fault instruction.
Correct.
And so, what instruction in lieu of comparative fault should have been given, or any? What did you propose?
An instruction that told the jury that you have to determine if Melissa Cerruta was negligent. The jury could have had the right to just say, yeah, this mom just fell asleep and she wasn't negligent. There was not a legal basis to tell the jury, well, if this lady falls asleep, then you can assess 50% of the fault to her husband for doing it. The instruction should have been, was there any negligence at all? And the jury could have come back and said, no negligence. there was a driver behind the Saruta vehicle who saw the car swerve and fishtail and then go into the ditch and roll over. The accident was investigated by a trooper, Trooper Boyd, and in his report he says that Melissa, the driver, fell asleep while she was driving. She told him that she fell asleep. She did not tell the trooper that she was too tired to drive. She did not tell the trooper that a tire had been blown out or an animal ran onto the road or there was mechanical failure or the wind blew him. She just says that I fell asleep. And that's what the trooper concluded. In that trial, Mrs. Saruta said she did not blame Duskin for making her drive when she was too tired. She said that's not the case. She said she really doesn't remember. Question, had you been driving along and started yawning or having a hard time keeping your eyes open, would you have either stopped or woke Duskin up? Answer, yes. So she doesn't blame him. Mr. Saruta says, I don't know. I was asleep. She hit the rumble strips. She started screaming. And the next thing I know is we came to a stop and the wreck had occurred. And after this instruction, the jury returned a verdict of 50% fault on both parties. This court has ruled in the Amblin versus Hamblin case, the Akins versus Hamblin case, Kansas courts have recognized that a passenger owes a duty to exercise that care which a reasonable person would use for his own protection, for his or her own protection. It has never been recognized in Kansas that a passenger owes any other duty to any other passenger unless that passenger and driver were somehow involved in a joint enterprise or had a special relationship.
And why wouldn't father-son be a special relationship?
Because I don't know why that would impute a duty on Mr. Saruta to cause him to have to stay awake and control Mrs. Saruta when she tells them. I think what the special relationship is relating to, again, is tag team operation of a vehicle, that it's part and parcel of a joint enterprise.
What about the possibility that dad or mom has a responsibility to buckle the kid in? Wouldn't that be potentially a duty that a parent would owe to a child, even if they're fellow passengers?
That could be, Your Honor, except for the statute that says that admissibility, that evidence is not admissible to a jury. Right. That, as for purposes of comparing fault or assessing fault, there's a specific statute that
right.
applies that. The Court of Appeals, in their ruling, relies upon case law which discusses a passenger or a sleeping passenger having a duty to use reasonable care to prevent an injury to himself or herself. For example, the 2-to-1 majority of the Court of Appeals in the Smith versus Union Pacific Railroad case says that generally it can be said it is the duty of the passenger while riding in an automobile driven by another person to use care that a reasonable person would use for his or her own protection. Again, that's a standard applying to a person being responsible to control a driver to protect themselves. That's different than a standard being imposed on a passenger to control a driver to prevent the driver from injuring a fellow passenger. The Court of Appeals also in their decision relied heavily on the Sledge case, which is a Louisiana case, which specifically says the opposite of what we have in this case. Although a passenger ordinarily has no duty to supervise a driver, fault may be imposed where there is a joint venture. Again, we didn't have a joint venture instruction in this case. And if we did, it may very well have changed the outcome of the case. In conclusion, I want to cite Judge Hill's dissent and the logic that he uses. He notes that in this claim, it is not a claim for Duskin Saruta's injuries. Instead, it is a wrongful death action. In essence, this is an action that Tate, the deceased son, could have filed had he lived. Tate had no more cause of action against his father than he did against the other passenger in the car. What Judge Hill is saying is if Tate was an adult and was injured, he would not have any cause of action against his father, nor would he have any cause of action against the other passengers in the car. His cause of action would lie solely against his mother, who was driving the vehicle. We ask that the Court of Appeals decision be reversed and the matter be remanded back to the district court for a new trial.
Any more questions? Thank you, counsel.
May it please the court, counsel, my name's Kevin M. McMaster, and with me on the briefs was Jennifer M. Hill on behalf of Melissa Saruda, the appellee cross-appellant in this case. There is no dispute that this was a tragic accident that occurred when a mother and father took a trip that included their 7-year-old son and another boy to a wrestling tournament. Unfortunately, on the way home from that trip, there was a single vehicle accident, and I think the key there is accident, that resulted in the death of this couple's son. What's also undisputed is no one knows what caused the accident. The accident could have been caused by weather. The accident could have been caused by a mechanical problem with the vehicle. Accident could have been caused by a blown tire. The accident could have been caused by the driver trying to avoid an animal that was on or near the highway. No one knows. Those things were not investigated. What was known was Dad was asleep and Mom doesn't remember. And yes, Mom assumed, and the investigating officer also assumed, the most likely scenario was that she had fallen asleep or dozed off. But what we also know is in the state of Kansas, negligence is never presumed. There has to be evidence of a violation of a duty. This is not a case where we have somebody running a stop sign, which there's a statute saying you're not supposed to, and causing an accident. We have a case that the plaintiff presented it, Mom might have fallen asleep, and because there's an accident, somebody's got to be at fault.
Except we do have a witness who was following the car, who saw the car swerve.
Yes.
Who saw it leave the roadway, overcorrect, go to the other roadway. So we do know there were traffic violations.
What we would submit, Your Honor, that the car swerving is not a violation of the traffic code.
Leaving the lane is not a violation?
Leaving a lane of travel is not a violation of the traffic code in and of itself. I mean, if you leave your...
Unless there was an obstacle that prevented you from...
You're supposed to maintain your lane of travel unless you have a reason to change it. Now, just merely leaving a lane is not a violation unless there's some resulting injury. A person can pull off the highway without violating the traffic code. And that's the key here is when we get down to it, the only allegation of alleged potential negligence is merely speculation that she dozed off. She fell asleep. Which again, in and of itself, if you look at the case law we cited in our brief, is not negligence. In and of itself.
Isn't speculation another word for circumstantial evidence? I mean, don't we have circumstantial evidence that she fell asleep?
We would submit that the circumstantial evidence doesn't support a cause. What it does is just gives people a reason to speculate. Circumstantial evidence of her actually falling asleep being the cause of the accident, we would submit being Mom or Dad testifying, it was a long day, I was tired, I was concerned about staying awake. That we would submit would be circumstantial evidence of falling asleep. What we have direct evidence of is there was an accident, period. But we don't have any evidence that we think reaches anything other than speculation or surmise that...
Is that the issue before us, the sufficiency of the evidence of negligence? I thought we were talking about the instruction about comparing negligence.
The cross appeal directly goes to the sufficiency of the evidence, Your Honor. But we would submit...
So that's prophylactic because basically your client won.
Yes.
And so you're making a prophylactic argument that if we decide that the instruction should have been given, it doesn't matter, it's not reversible because there wasn't enough evidence. Is that
Correct.
where
There
we are?
there should have been a summary judgment granted, or there should have been a directed, what was then called a directed verdict, now a judgment as a matter of law. But what ends up happening is when you look at it, the allegation is that she fell asleep, be it circumstantial or otherwise. That's what the plaintiff was pinning the hat on. And then you have to take into account that mom and dad shared the decision-making on the 2-day trip. Mom and dad shared the decision-making on the late-night drive. They shared the decision-making on who was driving when and who would drive for how long, etc. And that tied into the requesting permission to take a nap. So that comes into the fallacy to the instruction being wrong and comparing the fault. If the plaintiff was claiming the fault was she fell asleep, then the people who made the decision that she would be driving and he would be sleeping fault, if any, should be compared. And that's what we would submit is what made that instruction appropriate.
What about the point raised that there was no joint enterprise or joint venture instruction provided?
We requested one, and frankly, Your Honor, we think that the district court judge sort of split the baby and compared the fault as opposed to also doing that and giving a joint enterprise. If you go through the elements of joint enterprise, an agreement, clearly an agreement. The testimony's right on line. A common purpose, clearly a common purpose with regards to what was going on in this case. A community of interest, clearly there. An equal right to voice and control, clearly there from the standpoint of who was going to be driving when. So you have all of those elements. This fits smack dab into a textbook joint enterprise. And
So is every family vacation, every road trip taken by college kids who get in a car and travel down I-70, there's probably 500 of those as we're talking right now on Interstate 70 in this state. All those are joint enterprises?
No, we would submit they're not.
Why
Your
not?
Honor.
What's the difference?
Because there would be, all the elements wouldn't be met. Let's talk, for example, about a bunch of college kids crawling into a car
They
and
all
driving down.
they all agree we're going to share the driving. One of them maybe has the ownership of the car, has permission to use a car, and we're going to go to, south for spring break. We're going to Padre Island. Why isn't that a joint enterprise?
Well, when I was a college kid, we didn't all agree ahead of time we were going to share the driving.
Well, let's just say that's pretty common.
But what I would submit is common in that extent is there's an owner of the car. Only one owner of the car is that group of kids in the car, and that person's in control of who drives when. So you don't have the shared ownership and the shared decision making. That owner starts out the drive, and then he or others decide if it's too long. So I would submit that you don't have all the elements anytime a group of people get in a car. I think this
So
is...
every family vacation, same thing, is a shared is a joint enterprise.
If the evidence came in the same, I would say that family vacation, yes. But I would submit that more often than not, you don't have the situations where the driving is shared so equally. And the decision-making, as the evidence came in here, was so uniform with regards to, and then the point of asking if it's all right if I take a nap. So we would submit that this is a unique situation and that joint enterprise is applicable. And the only reason the commercial cases out there, or the cases generally involve commercial cases, is because you don't have this unique set of facts that you have in this case.
As I recall, you cited the Howard versus Zimmerman case that was the two young men that took the two young women from Sterling to Hutchison on a date, basically. Why is that different from what you have just used to distinguish with Justice Rosen?
I think that case is different because the date is short in duration, and there's not necessarily the agreement with regards to the planning of the trip of how many days it's going to take and how the driving is going to be shared, and the driving actually being shared that way. We would submit that these facts are specifically unique because if you go through our brief, they almost shared the driving had they completed the trip successfully equally with regards to miles, time, etc. And that's what we think is the difference, number one. And number two ties into the fact that it's mom and dad, it's parents who have different duties with regards to the deceased son, as opposed to just a date. And that's what we think is distinct there.
Are you saying that the special relationship applied here in addition to the joint venture?
Yes.
Joint enterprise?
I think they go hand in hand. And there was a question asked of opposing counsel. It ties into the fact that mom and dad had an equal obligation and right to see that their son was properly secured in a proper child restraint device, which was clearly the cause of this child's death. And they chose not to, and that's a distinct and different, and that ties into our request that that statute relied upon by plaintiff be declared unconstitutional as it relates to the facts of this case. Clearly, that statute was written so that a driver of an automobile who causes injury to somebody else can't use the fact that that person was not in a proper restraint system as a defense to the claim of injury or damages. But this is a case where it's parents who are not properly securing their child, which we would think is distinctly different and unique and is an improper application of that statute. And that ties into that statute, the joint emprise, and also the negligence or duties of the parties.
If they had a special relationship such that they had a duty to secure the child, why would they also have a duty to make certain that the child was protected from a sleeping driver? I mean, why does the duty end at buckling the seatbelt?
I don't think it ends at buckling the seatbelt. I mean, I think the application of the duties are because of the unique nature of these claims. This is not a claim that mom crossed the center line and hits another vehicle head on. Violation of the duty of driving in the right lane. This is a case where plaintiff's whole claim was mom dozed off. Mom dozed off, and her dozing off wasn't her making the unilateral decision of I'm going to drive at this time and I'm going to drive when I think I'm drowsy or something like that. This was a joint decision of mom and dad of who was driving when, and that dad was going to take a nap.
If we had the situation where they left the wrestling tournament and dad said, well, wife, I'll see you later, take the children back safely to Colby, and nobody bothered to check on whether the young man here who died later was properly restrained by seatbelt or anything else, and dad decided he would just stay at the wrestling tournament, is it your view that dad had a special relationship with his son and he therefore has violated some duty to the son by not ensuring that the safety belt was fastened?
No.
It is not.
I think the special relationship of mom and dad with regards to the child restraint system has to do with them occupying the same vehicle with the child. Now, I can, because dad says, I'm staying, you're driving. I think the responsibility there is mom's. Now, if dad says to mom, and we had evidence of mom and dad had this conscious decision of we're going to violate the law and we're not going to have the kid properly restrained, which I don't think was the case. I think they had the seat, it was being improperly used. So I think the duty is because they were operating or involved in the operation or occupancy of the vehicle with their son in violation of that child restraint system.
Well, I'm trying to separate, if we can, the joint enterprise factors from special relationship factors. Is that possible?
Yes. I think it's difficult, but I think it's possible because I think the special relationship required as required in connection with the joint enterprise includes the fact that they were parents. But I think the factors, as you pointed out, are different if the facts were different and dad wasn't in the vehicle. Let's assume that the other person in the vehicle wasn't dad and it was a 24-year-old boyfriend or something, and I'm just talking hypothetically to change it. That passenger doesn't have the same duty, I would submit, as a natural parent of the child who's not properly buckled in.
So if dad had exited the vehicle in Waukene and mom drove off alone, does the special relationship have any bearing on this case?
No. Either for the joint venture or for any other reason, because he wasn't in the vehicle. He was no longer part of the trip. He was no longer part of the decision-making, etc. We'd submit clearly both summary judgment and or a directed verdict were appropriate because there was no evidence of negligence. And we'd submit that the reason the court did the comparison of fault was directly related to the fact that the court was allowing this to move forward based upon the speculation that the cause of the accident was mom fell asleep. And for those reasons, we think that the district court's rulings and the jury verdict should stand.
Can we go back to the summary judgment or the
Yes.
used to be the directed verdict? The
Yes.
two standards are basically the same, correct?
Yes.
And one of the ways that the U.S. Supreme Court has characterized the standard is, could any reasonable jury have found for the plaintiff on this cause of action?
Correct.
And they did.
Well,
Did
they
they?
found for the defendant in this cause of action. And we would submit by
On-
50-50, the jury knew there was going to be no judgment against mom. So they found for the defendant. We say no reasonable person because if you look at the standards, for somebody to be negligent because they fell asleep, they had to have some reason to believe that they were too tired to drive.
But the 50-50 split on this case is about the minimum you can get, is it not, in order for there to be the defense verdict?
Yes, it is
So
the very minimum.
So we're asking the judge to determine whether it's going to be a 50-50 or a 51-49. And the judge, perhaps in this case, says, that's kind of a close call, I'm going to let the jury decide that. Is that a fair characterization?
It's a fair characterization, but if you look at the dynamics of this lawsuit, we would submit that the reason the jury came back with 50-50 is they didn't want to come back with some ruling other than to explain to Duskin that he was as responsible for what happened to their child as his wife was. Because remind you, and this ties into the interspousal and the parental tort immunity, it ties into the fact that you had a husband and wife who lost a child, were living together, still married, suing each other, and according to the wrongful death statute, my client was entitled to recover a portion of anything that was awarded. And we would submit that that ties into the reason for the jury verdict, number one, and then number two, the district court, in not granting the directed verdict or summary judgment, didn't pay attention to the fact that if you look at the case law in the state of Kansas, merely falling asleep is not negligence. There had to be some evidence, and there was none. Dad thought it was all right for mom to drive and she wasn't too tired. Mom thought it was all right for her to drive and she wasn't too tired. I mean, there was nothing about the facts that were presented to the jury or presented in the summary judgment motion that would indicate that anybody had any reason to believe she'd driven too long or was too tired. And merely falling asleep, according to the case law that we cited, is not negligence. There has to be something in addition to that. Does that answer that question?
That does, thank you.
Then back to the interspousal and parental tort immunity, since my time is running out. We would submit that this is a unique case where if you look through the factors and the elements and the reason this court abrogated it was right, but there should be exceptions to it. And one of those exceptions should be where it is a parent who's married to the other parent and living together, involved in a mutual automobile accident, of bringing a cause of action. And it ties into the wrongful death statute and why summary judgment should have been granted on that. The wrongful death statute allows any heir, that means Melissa or Missy, could have sued herself so as to have won. But any heir can bring an action to recover on behalf of all. The wrongful death statute requires any recovery to be apportioned among all heirs at law based upon their loss. It doesn't give the court or the parties to the right to say, oh, I'm not going to recover for that heir because they were at fault, or I'm not going to recover for that heir for this reason. It doesn't give the court the right to say, I'm not going to apportion this recovery based upon the loss because one of the heirs was the cause of the loss.
Why doesn't it? Why, if as a matter of law, the law does not recognize that person's right to recover for the loss in another context, why does the wrongful death statute necessarily control that?
Because the wrongful death statute is not a common law right of a cause of action. It is a creature of statute, and therefore it has to be construed. And that's what this court
So is
talked.
comparative fault.
Right, but
And
that
we're talking about having to reconcile the two statutes, in essence.
I don't think there's any recollection. I don't think you don't have to reconcile both comparative fault and wrongful death, because the wrongful death talks about who can bring a claim and on
Which is
whose
Tate.
behalf it is.
On Tate's behalf. And Tate can, and there's no question that Tate could have brought this suit against his mother.
Correct.
And so doesn't that mean that the wrongful death action can be brought? And our question then is, how do we apportion damages to a person who is comparatively negligent? And that's why we have to reconcile the two statutes?
I would submit that you don't have to reconcile the two statutes if you modify the abrogation of parent-child and interspousal tort immunity. And I would submit that while I'm not looking at it, that the comparative fault statute and the wrongful death statute were both in place before the abrogation of interspousal and parent-child immunity. And so the reconciliation we would submit isn't of the statutes, but it's of the application of the common law aspect of the immunities between spouses and between parents. And I'd submit the aberration here is the fact that mom and dad can bring a cause of action, mom or dad can bring a cause of action for the loss of a child where mom and dad are the only two that are entitled to recover any damages, and one of those parents was responsible for that loss. And so we would submit, as opposed to trying to reconcile the statutes, we modify the abrogation of the parent-child and interspousal tort immunity. I see I'm out of time, so I'll stop arguing unless there are any other questions.
Do we have any more questions?
Thank you for your
counsel.
time.
You reserve 5 minutes for rebuttal.
Thank you, Your Honor. In brief rebuttal, the fallacy of the defense argument is, Melissa, we didn't do anything wrong, you can't find us that we did anything wrong, but Duskin, who's asleep, it's okay for you to be at fault, even though you were asleep. You can't have it both ways. The first statement that counsel makes is negligence is never assumed and there must be a violation of a duty. With the instructions that were given to the jury, no, Duskin Cerruta did not have a legal duty to control his wife from falling asleep so as not to cause injury to their son. There was no duty. And was a joint enterprise instruction requested? Yes. And was it given? No. So we ended up with this hodgepodge of instructions that didn't fit the case. We ask that the matter be remanded back to the district court for a new trial.
Before you sit down, since we have a little bit of time, would you respond to this point of falling asleep in Kansas is not negligence? And as a result, they should have had their motion for summary judgment and other dispositive motions granted, and this whole trial was just a big mistake?
I do not agree with that statement of the law that falling asleep. You just, unless she has some condition where you go from 0 to sound asleep, you know that you're getting sleepy. You know that you're getting tired, but yet you continue to drive anyway. That is what negligence is.
And your best case to support that proposition would be what?
Well, defense counsel is citing for the proposition that simply falling asleep is not negligence. okay? We're saying that you look at all the circumstances, okay? And were you getting sleepy? Was the driver getting sleepy? And if the driver was getting sleepy and continued to drive, that is negligence. So just to say ultimately what happened is I fell asleep, therefore I can't be negligent, is not a correct statement of the law.
Thank you.
I don't hear you refuting the statement that merely falling asleep is not negligence, that you have to prove something else. You've acknowledged you have to prove something else, that they were aware that they were getting sleepy, that they put themselves in a situation where they would be sleepy or something else. But do you refute that the statement that falling asleep, standing alone, does not meet the burden of proving negligence?
No, because if you're able to fall asleep and somehow continue to travel in your lane of travel at an appropriate speed, you can be asleep. But when you fall asleep and you start weaving off the road and going into the ditch, that's negligence.
I think what he's getting at is your proviso that unless you have a condition where you go from consciousness to unconsciousness instantly, like a narcoleptic or something like that,
Right.
you allow us have that might not be negligent.
Correct.
Maybe just
And
having
the-
a driver's license is a problem then, but
Correct. And the proviso would be, go ahead and fall asleep, but continue to maintain your single lane of traffic and don't run into anybody, then you won't be negligent. But when you fall asleep and you start failing to maintain a single lane, failing to maintain control of your vehicle, that is negligence.
Any further presentation?
No, Your Honor.
Okay, any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.